welcome back. If you are here for the first time, welcome to you especially, and I am glad you found your way here. You have found a rather quiet corner of the internet, and I hope it suits you well. This channel exists because people like you find something restful in the past, in old rooms and old words, in the particular stillness of a story that has already ended, that has been resolved one way or another by time itself, and that asks nothing of you now except that you listen. I find these old court records endlessly absorbing, not because they are dramatic, though occasionally they are, but because they are so thoroughly human. The same worries, the same small vanities, the same careful management of reputation that people have always gone in for, in every century you care to name. If the channel brings you any ease, any rest, any pleasure, it would mean a great deal if you subscribed. It costs you nothing, and it helps these stories find their way to other people who might need them. And if you are already a subscriber, then thank you. Thank you genuinely for coming back. Now, one small thing I would love from you, if you are inclined. Drop a comment and tell me where in the world you are listening, and what time of day it is for you. We have listeners drifting off at midnight in Melbourne, settling in for an afternoon rest in Edinburgh, listening on a lunch break in Toronto, or tucked in for an early night somewhere in the American Midwest. The thought that people in all those different time zones and climates and lives are finding something useful in these old Georgian courtrooms is, I must say, a rather wonderful thing to contemplate. Tonight's case is one that I hope will leave you more comfortable than it left our principal figure, a gentleman of Hampshire by the name of Edward Barton. Mr. Barton was an attorney of some standing, a man with a good estate and a good name, and a great many years of honest practice behind him. He had clients who trusted him, neighbours who respected him, and a reputation that stretched across his county and beyond. And then a bond for £83 came before the court, and his name was attached to one of the most serious charges the law of England could bring against a man in 1740. Forgery, a capital offence. So I hope your day, whatever it brought, did not bring quite that. Close your eyes when you are ready. Let your shoulders settle. Let your hands rest where they are comfortable. We are going back to April of 1740, to a courtroom in the City of London, to a case that turned on memory and handwriting and the competing claims of reputation. London, in the spring of 1740, was a city that never quite went to sleep, though it tried. By 10 o'clock in the evening, the last of the tradesmen had shuttered their windows along the Strand, and the watchmen had begun their slow, shuffling rounds through the narrow lanes that pressed in on either side of that great thoroughfare. The river, always present, always moving, caught the reflection of a half-moon in its broad, dark surface, the light breaking and reforming with each passing barge, each slow eddy at the foot of the stairs. April in this city was unpredictable. There had been cold nights earlier in the month, frost on the cobbles before dawn, the kind of chill that settled into the stones of old buildings and refused to shift until well past mid-morning. But by the middle of the month, a warmer current had found its way through the streets, carrying with it the smell of the river and the distant, uncertain promise of a different season. In the gardens behind the great houses, early blossom was showing. In the churchyard of St Dunstan's in the west, where Fleet Street bends and narrows before it meets the lanes around the Inns of Court, the oldest gravestones were greening with new moss, and the ground between them was soft underfoot. St Dunstan's in the west was not only a parish church, it was the beating heart of a neighbourhood that ran almost entirely on legal paper and legal argument. The Inns of Court stood to the north, their ancient buildings enclosing quiet gardens where barristers walked and thought, and occasionally stopped to argue with one another in the particular measured way of men who are always preparing for a larger argument. Attorneys had their offices along Fleet Street and in the warren of passages and courts that surrounded it. Names on modest brass plates, the smell of tallow and paper drifting out from open windows above. Clerks carried bundles of documents between chambers and courts, their arms full and their expressions ranging from bored to anxious, depending on the nature of the deadline pursuing them. Messengers arrived with sealed letters from the country, departed with replies. Process servers moved through the crowds with the particular purposefulness of men who have a writ to deliver and a fee to collect. The whole machinery of English law turned slowly and with considerable friction in these particular streets. It was not a glamorous machinery, it was not a fast one. But it was thorough in its way, and it had been turning for centuries, and it would go on turning for centuries more. Arguments that began in village disputes or in the offices of country attorneys made their way eventually to this small patch of London, grew more elaborate as they travelled, acquired counsels and affidavits and exhibits, and either resolved themselves or settled into the long, slow persistence of an English legal dispute, which could, if properly managed, outlast everyone originally involved. It was in this neighbourhood that the events at the heart of tonight's case had come to their most critical point. The dispute itself had begun in Hampshire, in the offices and kitchens and courts of a county that was then, as it is now, a place of chalk downs and river valleys and market towns connected by roads that were excellent in summer and extremely difficult in winter. But it was here, in London, in the office of the Protho-Notary of the Court of Common Pleas, that a bag of papers had been opened and a bond had been produced, and questions had begun to be asked that would eventually travel all the way to the Old Bailey itself. In your room now, everything is still. Whatever occupied the hours before this moment has grown quieter. It belongs to earlier in the day, or to yesterday, or to a time that is already becoming less immediate as you settle. The world outside is doing what it always does at night. It is slowing down. The particular urgency that carries people through daylight hours is draining away, and what is left is something simpler and more restful. You are exactly where you should be. Let the story come to you. You do not need to reach for it. You do not need to hold anything in mind or prepare yourself for anything. The story will find you in its own time, as the old things always do, arriving quietly and without announcement, settling in alongside you as an old account of human affairs, told at a pace suited to the late evening, to the body that is resting, to the mind that is beginning to release its grip on the day. We begin in the spring of 1740, in one of the most serious situations an English attorney could find himself in. A man named Edward Barton, gentleman, of the County of Southampton, stood charged at the Old Bailey with felonious forgery and fraud. The instrument alleged to be false was a bond for £83, a legal document bearing signatures and seals and the weight of 10 years of settled assumption. The names alleged to have been forged were those of his own clients. The men who would determine his fate were 12 jurors assembled in a court that knew all too well the gravity of what it was being asked to decide. This is where we begin. Not in the courtroom, not yet. In the quieter time before it, in the county and the world that produced the man and the moment. In Hampshire, in the summer of 1729, in a kitchen with a brick floor where a piece of parchment was sealed and signed and witnessed, or where a different piece of parchment was sealed and signed and witnessed, and where the question of which of those things had actually happened would not be settled, and would not even be properly asked for more than a decade. To understand what it meant in 1740 to be an attorney in England, it is necessary to set aside the associations of the word that have accumulated in the centuries since, and to think about the particular world of the Georgian legal profession and the society it served. An attorney in this period occupied a position that was respectable, but also precarious, trusted but also mistrusted, absolutely necessary, but also, in the popular imagination, slightly suspect. The jokes about lawyers were already old in 1740. They had been old for a long time. Attorneys were the working practitioners of the common law. They were not barristers who argued before the superior courts and lived within the collegiate world of the inns of court, dining together in their great halls, calling each other to the bar, maintaining the traditions and the rankings of a profession that considered itself rather above the merely commercial. Attorneys were different. They were admitted to practice in the courts of common law by a process of examination and registration, and they handled the ordinary business of legal life, the drawing up of deeds and wills and settlements, the management of disputes between neighbours, the pursuit of debts through the courts, the defence of clients before the lower tribunals, the innumerable papers that English law required for the transfer of property, the settlement of estates, the appointment of trustees, and the endless negotiation of claims and counterclaims that accumulated whenever two people had an agreement that one of them later thought was less favourable than it had appeared at the time of signing. A country attorney, such as Edward Barton appears to have been, was a man of particular standing in his locality. He was educated at a time when formal education beyond the most basic level was a mark of social distinction that set a man clearly apart from the majority of his neighbours. He was familiar with the machinery of the courts at a time when most of his clients had little idea how that machinery worked, what it cost, or how long it took. He knew the names of the judges. He knew which officers of the court were useful to know, and which could be ignored. He understood the difference between an action in common pleas and one in King's Bench, and he could explain that difference to a confused farmer or anxious tradesman in terms that gave the client enough understanding to proceed without overwhelming them with the full complexity of what was actually involved. He moved, in short, between two worlds. On one side was the world of the gentry, the squires and magistrates and clergymen and landowners who dominated county society, and whose affairs, whether testamentary or contractual or litigious, provided a substantial part of a country attorney's business. On the other side was the world of the tradespeople and small farmers and craftsmen and tenant farmers who made up the great majority of rural Hampshire society, and who came to an attorney when they had run out of other options, which was to say when they were sued, or when they wanted to sue, or when a relative had died and left a will that someone else was disputing, or when a debt had grown so large that informal management was no longer possible. The attorney was a man to whom people came with their difficulties, their disputes, their accumulated troubles, trusting that he had the knowledge and the connections to help them through whatever complication had arisen. And in return for that trust, the attorney charged. He charged for his time, for his travel, for his correspondence, for the papers he drew, for the courts he attended on the client's behalf, for the officers and process servers and clerks whose fees he paid and then reclaimed. These charges accumulated over a long period of business into what was called a bill of costs, a document that itemized every act of service and attached a price to it, and which, at the end of a long relationship, could amount to a very considerable sum. The relationship between an attorney and his clients was, by its nature, intimate in a way that other professional relationships of the period were not quite. Clients disclosed their affairs, their finances, their family arrangements, their debts and their assets and their embarrassments. They trusted the attorney with papers of great importance, with money held on their behalf, with the management of lawsuits that might determine whether they kept their homes or their businesses or their liberty. And the attorney, in return, was supposed to act faithfully and honestly, and with the client's interests as his primary consideration. He was not supposed to charge more than was reasonable. He was not supposed to prolong suits unnecessarily for the sake of fees. He was not supposed to use information gained in confidence against the client who had confided it. The reality, of course, was more complicated. Bills of costs were disputed constantly. Clients who had been pleased with their attorney while the suit was progressing became rather less pleased when the bill arrived. The process by which bills were reviewed, called taxation, was a standard feature of legal practice, and the prothonotary of the Court of Common Pleas, or equivalent officers in other courts, was frequently called upon to go through an attorney's bill and determine what was reasonable and what was not. This could result in significant reductions, which infuriated attorneys and satisfied clients, or very modest reductions, which did the opposite. The relationship between lawyer and client, once it had broken down to the point of a taxation, was rarely repaired. When that relationship broke down entirely, the consequences could be catastrophic for both sides. A client who felt systematically cheated might pursue not merely a taxation but a complaint to the court itself, seeking the attorney's removal from practice, or might go so far as a criminal prosecution if the evidence supported one. An attorney who believed himself genuinely owed money, and who had a bond to prove it, might move to enforce that bond, seek a writ of execution against the debtor's goods, and pursue the matter through every available legal avenue until either the money was paid or the relationship had generated as much legal business as it had originally involved. Bonds, as legal instruments, were central to this world. The sealed writing obligatory, as it was formerly known, was among the most powerful documents available in 18th century English law. It was not a simple acknowledgement of debt, though it contained that. It was a formal obligation executed with seal and signature and witnesses, creating a legal reality that was extremely difficult to challenge once it existed. The party named in the bond as owing the money was bound by its terms, and the holder of the bond could go to court to enforce those terms, could obtain a writ directing the sheriff to seize the debtor's goods, and could in extreme cases pursue remedies that touched on the debtor's person, not merely his property. A bond was typically written on parchment. Parchment was more durable than paper, more resistant to the ordinary deterioration of time and damp and careless handling. And its use for important legal documents was a tradition that went back centuries and would continue well into the 19th century. The bond was written in a mixture of printed and handwritten text. Since by the 18th century, printed forms existed for the standard elements of a bond, with spaces left for the particular details: the names, the sum, the date, the conditions. These spaces were filled in by hand, and the filling up of the bond, as contemporaries called it, was an act that left the attorney's or the clerk's handwriting on the document alongside the signatures and marks of the parties and witnesses. Witnessing a bond was a serious act. The witnesses did not merely observe the signing, they attested to it, they put their names or marks to the document, they became part of the legal record of its execution. If a bond was later challenged, the witnesses would be called upon to confirm what they had seen, when they had seen it, who else had been present, and what exactly had happened in the room. Their memories, sometimes stretching back years or even decades, became evidence in disputes that turned on the finest details of who had been where and what they had done on a single afternoon. Forgery of a bond was, in 1740, a capital offence. The law took a severe view of fraudulent manipulation of legal documents, and with some reason. The entire credit system of the country ran on paper and trust. Merchants extended credit on the strength of bonds and bills and promissory notes. Landowners mortgaged their estates on the security of sealed documents. The courts themselves depended on the reliability of the instruments placed before them. If those instruments could be fabricated or altered with impunity, the entire structure of commercial and legal life would become uncertain in a way that could not be tolerated. The Forgery Act of 1729, passed just weeks before the date of the bond at the centre of this case, had tightened the law considerably. It made the forging or uttering of various categories of document, including bonds, an offence carrying the death penalty without benefit of clergy. That last phrase meant that the traditional escape route by which a literate man could claim the privilege of the church and have his sentence reduced from death to branding was closed. A man convicted of forging a bond in 1740 faced the gallows at Tyburn. The public procession through the streets, the great crowd assembled to watch, and the end of everything. This was the charge that Edward Barton faced as he stood in the dock at the Old Bailey in April of 1740. Not a technical charge, not a procedural irregularity, not a civil dispute dressed up in criminal language, a capital felony, a charge that, if it resulted in a conviction, would cost him his life. And yet the case against him was constructed almost entirely from the testimony of people whose characters, according to a very substantial body of witnesses, were not to be trusted. This collision between a grave charge and disputed character evidence was the central tension of the trial, and it ran through every hour of the proceedings. Let your breathing slow now. There is no hurry. The story will unfold in its own time, as it did in that courtroom almost 3 centuries ago. You are warm, you are comfortable. The night is yours. The Sessions House at the Old Bailey stood in 1740, much as it had stood for several decades, though it was not yet the building that would be rebuilt later in the century, and rebuilt again in the century after that. It sat at the junction of Old Bailey Lane with Newgate Street, just at the point where the city's western edge had been defined for centuries by the great walls, and subsequently by the prisons and courts that had clustered around that old boundary. To one side of the Sessions House stood Newgate Prison, its dark stone walls absorbing whatever light fell on them. Its interior, a world that the reformers of the period were beginning to describe in terms that would make later generations shudder, though the reformers themselves had to fight for decades before anyone with power over the situation was moved to do very much about it. The court itself was remarkable in one respect that no visitor failed to notice, and most visitors failed to entirely believe. One side of it was open to the air. Not open in the metaphorical sense of having large windows, but literally open, giving onto a small enclosed yard that separated the court from the street, so that weather and wind and the sounds of the city entered freely. This arrangement had not come about by design, but by necessity, and a grim necessity at that. The jail fever, which we would now recognize as typhus, had swept through the court on more than one occasion in earlier decades, carried in on the persons of prisoners brought from the filthy conditions of Newgate, and it had killed not merely the prisoners but the judges and barristers and jurors who sat in the same enclosed space, breathing the same contaminated air. Chief Justice Sir John Holt had nearly died of it. Several of his colleagues had not been so fortunate. Opening the court to fresh air had been the practical response, and it remained the arrangement in 1740. In April, this meant that the court was cold, or at least chilly, depending on the wind direction and the time of day. Witnesses who had travelled from Hampshire, some of them gentlemen of property, and magistrates who were accustomed to a degree of comfort in their daily lives, found themselves giving their evidence in a draughty room that smelled of the city, and the occasional whiff from the direction of Newgate. The judges on the bench had their robes and their dignity to protect them from both the cold and the incongruity of the setting. The lawyers had their gowns. The jury had only their coats and the fellowship of other people in the same uncomfortable situation, which is perhaps the oldest comfort available in a jury box. The court sat through the session, which typically ran for several days. Each day began early and ran until the business of the day was concluded, which meant that the pace of proceedings was considerably faster than anything a modern court observer would recognize. A trial that in the 21st century might occupy several weeks, with elaborate procedures for the selection of the jury, the examination of witnesses, the submission of documentary evidence, and the summing up, would in 1740 have been conducted in hours. Witnesses were called, examined, and cross-examined in rapid succession. The judge asked questions when something struck him as requiring clarification. Counsel on both sides put their points with economy, because they had other cases to attend to before the day was out. And the jury, having heard everything, retired briefly and returned with a verdict. The particular session in which this case was tried had been running since the 16th of April, 1740. The published accounts of the proceedings, which the court had been producing since the late 17th century, and which give us the record from which tonight's story is drawn, contain 40 cases from this single session. Thefts and robberies and frauds and assaults, and at least one murder, all tried in rapid succession by the same judges and by juries that serve through multiple cases in a single day. For a case like Barton's, which involved questions of handwriting that needed to be looked at carefully, questions of witnesses whose testimonies contradicted each other in specific and important ways, a dispute about the circumstances of an event that had taken place more than a decade before, and which brought into the court some dozen witnesses from Hampshire alone, simply to speak to the characters of the various parties involved, the proceedings would have occupied a substantial portion of the court's available time. The public gallery of the Old Bailey in 1740 was not a restrained space. People attended trials as they attended other public entertainments, and a forgery case involving a gentleman of substance had a particular appeal. It was not the raw theatre of a murder trial, but it had its own qualities. The legal complexity, the battle of character evidence, the question of who was to be believed and why. The sight of a man of standing, brought low by a legal document and forced to defend himself before the court. Apprentices and tradesmen and curious citizens of all kinds would have been in the gallery, listening as best they could over the ambient noise of a room that was never quite silent. The clerk of the court read the indictment in the formal language of the law, a language that had its own rhythm and weight, and that announced through its very formality the gravity of what was being charged. Edward Barton, the elder gentleman of the county of Southampton, was charged with feloniously and fraudulently making, forging, and counterfeiting, and causing to be made, forged, and counterfeited, in the parish of St. Dunstan's in the West, on the 25th of February, 1739, a certain sealed writing obligatory called a bond, with the name of George Collins subscribed thereto, and the counterfeit mark of Nicholas Collins thereunto made, with a condition importing an obligation for the payment of £83, and bearing date the 9th of June, 1729. With intent to defraud the said George Collins and Nicholas Collins, against the form of the statute. He was further charged with uttering and publishing the same instrument in the parish of St. Dunstan's in the West, knowing it to be false, forged, and counterfeit. To these charges Mr. Barton entered his plea of not guilty. The jury was sworn, and the counsel for the prosecution rose to open the case. The counsel for the prosecution began with a careful account of the background to the case, setting out the history that had brought these parties to this courtroom. He told the jury that Mr. Barton had been employed as an attorney by the two Collinses, meaning George Collins and his brother Nicholas, in several lawsuits, a period of legal business that had extended over some years. The work had been done, the bills had accumulated, and by June of 1729 the sum of £84, 16 shillings and sixpence was, as Mr. Barton maintained, due to him for business transacted and money expended on their behalf. The Collinses, being what counsel described only as unable to pay in ready money, had given Mr. Barton a bond for £83 as security, accepting the small abatement he offered as a gesture of accommodation. The witnesses to that bond, he said, were Honor Luff and Nicholas Luff. He then described what had happened subsequently. The Collinses had at some point become dissatisfied with Mr. Barton's acting as their attorney. They had engaged another man, a Mr. Reed, another attorney in the neighbourhood, to transact their future legal business. This change in representation had not gone smoothly. Mr. Barton, upon learning that he had been replaced, had begun to put the bond into execution, that is, had moved to enforce the legal obligation and recover his £83. By Mr. Reed's advice, the Collinses had complained to the Court of Common Pleas, and had prayed that the whole affair, and all the accounts subsisting between them and Mr. Barton, might be examined and settled by the Prother Notary. This was granted. Mr. Barton appeared personally before the Prother Notary, and when required to produce his documentation, he produced the bond. And this, said counsel, was where the trouble began. The bond that Mr. Barton produced was, the Collinses maintained, not the bond they had given him. Or rather, it was not exactly right. They acknowledged that a bond had been given. They acknowledged the sum of £83. But they said that on the back of the true bond there had been an endorsement of £20, representing a part payment they had made, and for which Mr. Barton had given them a receipt. That endorsement was not on this document, and more than that, the witnesses named in this document were not the witnesses who had actually been present. Honoria Luff, who was named as a witness, said she had never witnessed a bond with young Mr. Barton as the other witness. With this opening before the court, counsel for the prosecution called his first witness. John Collins the elder was the first to give his evidence. He was a man from Hambledon in Hampshire, a village in the chalk country south of Winchester. A man whose family had been at the centre of this dispute from the beginning, and whose presence at the trial would, as the day went on, attract considerable commentary from the witnesses on the other side. But at this point he was simply the first witness for the prosecution, a man who knew the parties, and who had been asked to give his opinion on the handwriting in the disputed document. He was careful from the outset, choosing his words with some precision. He said, "I have known Mr. Barton the elder many years. I never saw him write his name himself, but I have seen his name to a great many papers. I am acquainted with his handwriting, and I believe the filling up in the body of this bond may be his handwriting. I have seen him write other writings, though I have not seen him write his name, and I believe this filling up tallies with his manner of writing. I believe so, but I can't be positive to such things." He was careful to offer belief rather than certainty, and to distinguish between what he knew directly and what he inferred. This was not the testimony of a man claiming absolute knowledge. It was the testimony of a man who had observed closely over many years and was giving his honest opinion hedged appropriately for the significance of the occasion. Then he was shown the signature, the name George Collins written on the bond opposite the first seal, and here his answer was rather more definite. He said, "The name, George Collins, which is opposite to the first seal, I believe is not George Collins's hand, to the best of what I know. Here are several letters not like his writing, the C for one, and likewise the E, none of them compares rightly with his hand. I don't say all of them. Some of the letters may. To the best of my knowledge, this is not George Collins's writing." Again carefully hedged, again offering belief and not certainty. He could see in the letters something that did not match what he knew of George Collins's hand, but he was not prepared to go further than that. He could point to specific letters, the C and the E, as being wrong. He could say that the name did not compare rightly with the hand he knew. But he would not say, flatly and without qualification, that the signature was forged. The difference between a belief and a certainty, in a capital case, was a difference that a careful man would insist upon. The second witness for the prosecution was John Collins the younger, and his account was considerably more detailed and considerably more narrative in its character. Where his father had confined himself to opinions about handwriting, the younger Collins gave the court a story, a picture of a specific meeting and a specific conversation from which the jury was invited to draw its own conclusions. He began with his acquaintance with the parties. He said he had known Mr. Barton for 10 or 11 years, and by sight for 20. He was a tailor by trade, living with his father. On the handwriting in the body of the bond, he offered the same measured opinion as his father. He said, "The writing in the obligation part of this bond I take to be Mr. Barton's the elder. I have been acquainted with his manner of writing 6 or 7 years, and this is very much like his handwriting, for I have seen him write several times. As to the filling up of the bond between the printing, I take it to be Mr. Barton's the elder, but I can say no farther than my belief." But then he came to the signature, and instead of simply offering a handwriting opinion, he gave an account of something he said he had heard with his own ears. He described a conversation that had taken place at Mr. Barton's office in the Hop Garden in December of 1735. He said he had been present together with George Collins and Mr. Barton, and that there was no one but the three of them in the room. The occasion, he said, was a meeting at which Mr. Barton had raised the question of money owed to him. He described the atmosphere. Mr. Barton seemed in a stern humour with Collins. He told Collins that he owed him a great deal of money, that he could not keep the injunction on foot, and that if he did not, there would come out an execution against Collins, and his stock would be taken. "And how," says Mr. Barton, "shall I raise money?" Collins had answered by raising a different grievance. "Why, if you had paid Mrs. Bailey's £200 off, as you have had the money, that would have put a stop to this affair." This reference to Mrs. Bailey and her £200 opened a vista onto a much larger financial entanglement between Barton and the Collins family, involving a debt and a security and money that had, according to Collins, been received by Barton but not applied in the way it should have been. Mr. Barton had told Collins he owed him a great deal of money himself, and Collins had responded with what the witness described as a full accounting of what he believed he had already given. "Sir," says Collins, "what would you have me do? You have got my all. I have assigned everything to you. I have given you a bond of £83, witnessed by 2 persons, and an £80 bond to make up the money to pay Mrs. Bailey off." The younger Collins then came to the crucial point of his testimony. In this conversation, he said, George Collins had referred specifically to the witnesses of the £83 bond. He said, "You know I have given you a bond for £83, and Nicholas Luff and Honoria Luff were witnesses to it." And Mr. Barton had confirmed this, replying in the affirmative to what Collins had said. This was the significance of the testimony. If the jury believed this account, then Mr. Barton had confirmed in the presence of a witness that the original bond had been witnessed by Nicholas and Honoria Luff. The bond he later produced before the Prother notary named Honoria Luff and his own son as witnesses. If those 2 things were both true, then one of the bonds was not genuine. Collins had also raised the matter of the £20 payment at this meeting. He said, "You know I have paid £20 off that bond, and have your receipt for it." Mr. Barton replied that he did not remember it. If he had, he did not know what to say to it. But if he had, it must be so. The witness then added a detail about an earlier occasion at Mr. Barton's office that gave the court a glimpse into the texture of the relationship between this attorney and his clients. He said that on a previous visit, when he had come away from the office, Mr. Barton had read a paper to him and told him that if he would get George Collins to sign it, he would make him a handsome present for a pair of gloves. George Collins was not present when Mr. Barton said this to him, and the witness did not remember what the contents of the paper had been. This detail was not straightforwardly incriminating. An attorney asking a client's relative to help obtain a signature was not inherently improper. The client might have been difficult to reach, or might have been hesitant, and the attorney might simply have wanted an introduction. But placed alongside the other evidence, alongside the disputed bond and the missing endorsement, and the question of which witnesses had really been in the room, the detail suggested a pattern of seeking, one way or another, to secure documentation for claims against the Collins family. Whether the jury would see it that way was another matter. Counsel examined the witness further on the conversation in December 1735, drawing out additional details about the financial entanglements. John Collins, the younger, explained that Mr. Barton had agreed in that conversation that Collins had given him an £80 bond to make up the money to pay Mrs. Bailey, and believed he had told Collins that he had been security to Mrs. Bailey for the money Collins owed. He was then asked by the prisoner's counsel whether the £80 bond had been given to indemnify Mr. Barton on account of that security. He replied that he did not know that, but confirmed that Mr. Barton had been security for George Collins to get him out of jail. He was asked to confirm there had been no mention of any other £83 bond, besides the one witnessed by Sister Luff and Nicholas Luff. He confirmed no. There had been only one such bond mentioned in the conversation. The counsel then showed the witness several papers signed with the name of George Collins and asked him to examine them. He looked at each one carefully and said that all of them he believed to be George's handwriting, except one, which he believed was not. Then came the witness who, in terms of direct and particular relevance to the charge, was the most important the prosecution had. Honoria Luff was called to the stand, and the court settled its attention on her with a particular alertness, for she was one of the two witnesses named in the original bond, and whatever she said about the document now in evidence would carry unusual weight. She was a woman of modest background from Hambledon, related to Nicholas Luff, who would also give evidence. She had been present, she said, at the execution of the genuine bond in 1729. She knew the parties, and she had a very precise and very particular reason for being sure that the bond before the court was not the one she had witnessed. She began with a clear statement of what she knew. She said, "I know both Mr. Barton and the two Collinses, George and Nicholas. I remember their giving Mr. Barton a bond for £83. I was one of the witnesses to it, and Nicholas Luff was the other. And I never was a witness to any other, but one. And in that one, John Hyde was a witness with me. But I never witnessed a bond for £83 in my life, with Mr. Barton the younger." She then explained the specific logic of her position. She said, "When George and Nicholas Collins gave Mr. Barton the £83 bond, I made my mark as a witness, and Nicholas Luff wrote his name to it. But I am very sure the mark upon this bond is not mine, because here is not the other right witness's name, but young Mr. Barton's, and therefore I apprehend 'tis not my mark. If it had been mine, Nicholas Luff would have been the other witness." This was a careful and logical argument. She was not merely saying that she did not recognize the mark on the disputed bond as her own. She was saying that the mark could not be hers, because she had never been a witness alongside young Mr. Barton, and the presence of his name as the other witness was therefore itself proof to her own satisfaction that this was not the document she had signed. Her certainty rested not on an examination of the mark itself, but on her knowledge of who had and who had not been present when she made her marks on legal documents. She was asked to describe the execution of the bond she had witnessed, to establish the circumstances of that occasion. She replied, "In George Collins's brick kitchen, George and Nicholas Collins were present, and Mr. Barton the elder, myself, Nicholas Luff, and Anne Luff, my mother." Then she added something that reinforced her position with particular directness. She said, "I can't say how many bonds given by the Collinses I have been a witness to, but I am sure I never witnessed any bond when young Mr. Barton was even in the same room." This went further than merely denying the specific occasion. She was saying that across all the documents she had ever witnessed, across her entire experience of such transactions, she had never been in the same room as young Mr. Barton. Not on one occasion. Not ever. Therefore his name appearing alongside hers on any document was, from her perspective, a practical impossibility. The prisoner's counsel asked her whether she had not said, at the time the mark was supposed to have been made, that she could write. This would have been a significant concession, because a person who could write her name would not have made a mark, and a mark made by someone who could write might seem suspicious. Her answer was direct. She said, "No, I never said any such thing." She was shown a bill of costs, which counsel for the prosecution had identified as the document in consideration of which the bond had been given. She confirmed that Mr. Barton had delivered this paper to George Collins at his house on the same day the bond was executed, and she said she had seen him write the receipt, and she thought she had seen him write his name to the bill, though she could not be entirely positive about that last point. She then offered a careful opinion on the signature of Edward Barton, Jr. that appeared on the disputed bond. She could write herself now, she said, and could read writing, but she did not pretend to know handwriting in the expert sense. Nevertheless, she said, "I believe this name of Edward Barton the younger was wrote by Mr. Barton the elder." This was a notable statement. She was suggesting not merely that the bond was false, but that the signature of Edward Barton, Jr. had been written by his father. If the jury believed her, then the entire document before the court was Mr. Barton Sr.'s creation, written in his own hand, including the names of the supposed witnesses. The bond was then formally read to the court, so that its full contents would be on the record. It was a bond for £83, signed Geo Collins and marked Nicholas Collins, attested by Honoria Luff and Edward Barton, Jr. The bill of costs, amounting to £84, 16 shillings and sixpence, was also read, along with the receipt written at its foot. June the 9th, 1729. Received then the sum of £83 by bond, for a security for the said sum, which when paid will be in full of all demands. Edward Barton, Sr. The prosecution then ran into a procedural difficulty. George Collins himself had been available to give evidence, and his testimony about what had actually taken place on the 9th of June, 1729, and about the alleged payment of £20 and the receipt given for it, would have been directly relevant to the charge. But the defendant's counsel raised an objection, that George Collins was concerned in point of interest. He was a party to the underlying dispute. He stood to benefit financially from the outcome of the case. This, under the rules of evidence as they then operated, made him incompetent as a witness. The court heard argument on both sides and upheld the objection. George Collins was not sworn. The prosecution would have to make its case without his direct testimony. In his place, counsel called a Mr. Warren, who had been involved in the proceedings before the Prother Notary. His purpose was to give the court an account of what had happened in those earlier proceedings, and in particular to establish that the matter had eventually been resolved, and that releases had been executed on both sides. Mr. Warren said he had seen a release executed by Mr. Barton the elder as his act and deed. It was produced in court. It was signed Edward Barton, Sr., and dated the 11th of February, 1737. He said there had been a release given by George Collins about a month before, but that no release had been given by Nicholas Collins. He gave further evidence about the Prother Notary's proceedings. He said carefully that the £20 mentioned in the opening address to the jury had never been mentioned in the earlier proceedings as being in discharge of any part of the £83 bond. Rather, Collins had had a suit with a widow Oakingham, and the £83 bond had been in discharge of law charges generally, not in connection with that particular matter. Under cross-examination by the prisoner's counsel, Mr. Warren was asked whether a demand had been made in respect of the bond. He gave an account of the prothenotary's approach, that Collins had complained the bonds had been given when the money was not all due, upon which the prothonotary had ordered a general bill of costs to be laid before him by Mr. Barton, and had ordered that no regard should be paid to the bonds themselves in the meantime. He therefore could not say the bonds had been considered or acted upon at all during those proceedings. The prothonotary himself, Mr. Cook, then gave his account of what had occurred in his office. He was a man who had handled this matter personally, who had seen the documents produced, and who could speak to what had been said and noticed during those proceedings. He said the affair had been before him about 2 years ago. He had intended to determine what was due from Collins to Mr. Barton, taking into account both the bonds and the taxation of the bills of costs, and to add the interest due upon the bonds to the overall account. Then he came to something of significance. He said that when this particular bond, which he had marked for identification, had been placed before him, an objection had been raised. The specific objection was this, that Mr. Barton had sworn that Honoria Luff had signed her name to the bond, when in fact she had only made her mark to it. He did not remember that any other objection had been made to the document at that time. This was an interesting detail for the court to absorb. Mr. Barton had, before the prothonotary, apparently described Honoria Luff as having signed her name. But the document itself, and her own testimony, indicated she had made a mark. This was a small discrepancy, but it suggested that Barton's knowledge of what was actually on the document, at least in this particular, had been imperfect. It was the kind of detail that could be explained in various ways, and the jury would have to decide what weight to give it. Mr. Warren confirmed the prothonotary's account on this point. No other objection to the bond had been raised during those earlier proceedings. Mr. Cook added that the bond had been produced at his office, which he deemed to be in London, as a demand for so much money, brought by a man named Drury, acting on behalf of Mr. Barton. Nicholas Luff then gave his evidence. He was the man whose name appeared on the genuine bond as the other witness alongside Honoria Luff, and his testimony went directly to the question of what had happened in George Collins's kitchen on the 9th of June, 1729. He said plainly and without elaboration, "I set my hand as a witness to a bond for £83 on the 9th of June, 1729. That Honor Luff was a witness with him at the same time, and that young Mr. Barton was not a witness to it, nor was he then in the house." He then described the gathering on that day. The persons present were George and Nicholas Collins, Honor Luff, Anne Luff the elder, Mr. Barton the elder, and himself. All of them were in George Collins's kitchen, which had a brick floor. He had seen no other paper or papers produced at that time. He had not, he said, been present throughout the preparation. He had been abroad, away from the house when sent for, and had come in to sign as a witness. He believed his sister Luff had been there throughout the proceedings. His testimony was brief and unelaborated, the account of a man giving what he could confirm directly, and nothing more. He had been there. He had signed. Honor Luff had been there and had signed. Young Mr. Barton had not been there, had not been in the house. That was what he could say. Henry Reed, the attorney who had taken over the Collinses' legal business, was then called. His position was somewhat awkward. He had been involved in advising the Collinses in their complaint to the Court of Common Pleas. He had attended the proceedings before the prothonotary. He was in a position to give evidence about the handwriting, and he was asked to do so. He said he had seen Mr. Barton the elder write, and that he believed the filling up of the body of the bond was his writing. But on the question of the name written in the witness line as Edward Barton, Jr., he became rather more cautious and rather more interesting in his caution. He said he had not seen Mr. Barton the younger write sufficiently to be positive whether this name was in young Mr. Barton's own hand. Then he offered an opinion that the court must have noted carefully. "'Tis a great deal more like Mr. Barton the elder's than his son's." He said he was unwilling to give a definitive answer because he could not speak with certainty. But he added, "It has the likeness in all respects to Mr. Barton's the elder, and is not like the younger's." He added that young Mr. Barton was 22 or 23 years of age, though he corrected himself immediately, saying he must be more than that. Then came the question of character. The prisoner's counsel asked Mr. Reed what he knew of the character of Nicholas Collins. And Mr. Reed, who was in this case a witness for the prosecution and an attorney who had worked for the Collins family, gave an answer that was rather more complicated than a simple endorsement. He said, "He is looked upon to be a man of an exceeding good character." Then he moved to the other witnesses, and his assessment became more nuanced. As to John Collins, Senior and Junior, and Honor Luff, "I know nothing of them myself, but their general character is that they are very troublesome people." He added that Honor Luff had been looked upon as one concerned in such affairs, but that he had not known her to forswear herself, and that he had great reason to believe the contrary, because he had never seen anyone more cautious than she had been when making her affidavit. He was asked whether he had had any conversation with one Hammond about the Collins family. He said, "I don't remember. I am not concerned in this prosecution, nor do I know the persons who are." Philip Bigg then gave very brief evidence. He had seen Mr. Barton the elder very often, but had never seen him write, and was but very little acquainted with young Mr. Barton, and had never seen him write at all. His evidence was of limited assistance to either side, establishing only the limits of his own knowledge. Mr. Reed was then recalled to confirm his observations at the prothenotary's office. He said he had attended there, and had been present when the bond was produced by Mr. Barton the elder. He said, "I remember his taking it out of a bag of papers, as a voucher, on the bills which were taxed, and to prove that he had such a demand." He said he believed this had been at the prothenotary's office. With this, the prosecution closed its case. The evidence before the court was two members of the Collins family giving their belief that the body of the bond was in Barton's handwriting, but that the signature of George Collins did not look right. Honoria Luff saying she had never witnessed a bond with young Mr. Barton, and was therefore certain the mark on this document was not hers. Nicholas Luff saying young Mr. Barton had not been in the house on the day the bond was executed, and Mr. Reed, offering the opinion that the name Edward Barton on the witness line looked more like the elder Barton's writing than the younger's. Against all of this stood the testimony yet to come. Mr. Barton rose to make his defence, and his account was presented with the thoroughness that a man of his legal training might be expected to bring to the management of his own case. He began at the beginning with the commencement of his professional relationship with George and Nicholas Collins on the 22nd of April, 1728. He told the court that in June of 1729, having transacted a great deal of business for the Collinses and expended money on their behalf, there was £80-odd due to him. The Collinses, he said, were lamentably poor. They had another cause pending in Chancery, and they were in no position to pay his bills in ready money. They had therefore invited him and his son to come and dine with them, promising to give him some security for the debt. He and his son had gone. The bills were laid before the Collinses and found satisfactory. The account was adjusted and found to stand at £84, 16 shillings and sixpence. At the request of the Collinses, he had abated £1, 16 shillings and sixpence as an accommodation. The remaining £83 was the subject of the bond. And to that bond, he said, Honor Luff had made her mark as one witness, and his son had written his name as the other. He then went on to give an account of the further business he had transacted for the Collinses after the execution of the bond, and the various counter-securities they had given him for his expenses and trouble in managing their affairs, and the series of transactions that had passed between them until the entire matter had finally been adjusted and settled through the prothenotary's office. It was a lawyer's account of a legal matter, detailed, sequential, concerned with the precise characterization of each transaction and each document. Whether the jury followed all of it is impossible to know, but the general impression it was designed to give was of a man who had done a great deal of legitimate work, had been owed a great deal of legitimate money, and had taken legitimate security for that money in the form of a bond that was exactly what he said it was. Then Edward Barton, the younger, gave his evidence, and it was the most directly confrontational testimony of the entire defence. He was the man whose name appeared on the disputed bond as the second witness, and he had been the one whose presence at the execution was most directly disputed by Honoria Luff and Nicholas Luff. He began by giving his age, carefully. He said he would be 30 years old on the 6th of November next. He had been his father's clerk when the bond was given, for better than a year at that point, and had been almost 19. He said, "It was usual for me to go with him to execute writings, and then, simply and directly, I am positive this is my hand to this bond." He said the bond had been executed at Exon, in the house of George Collins. He confirmed the figures, the bill of £84, 16 shillings and sixpence, the abatement of £1, 16 shillings and sixpence, the bond for the remaining £83. Then he gave a direct account of what he said had happened in that kitchen. I saw George Collins write his name to this bond. He sealed and delivered it, and Honor Luff was present at the same time. She made her mark to it, and I wrote my name to it as witnesses. This name, Edward Barton, is my own handwriting, and the writing of the mark of honour, Luff, is my father's. The bond, likewise, was filled up by my father. He was asked who had been present, and gave a full account. He said George and Nicholas Collins, George Collins's wife, Honoria Luff, Anne Luff, and a person who came in and out as a servant, wearing a carter's smock, whose identity he did not know. He mentioned that he had been a witness to writings as early as 1727, 2 years before the execution of this bond, and identified his own handwriting on the backs of other parchments produced in evidence. He was asked whether the bond had been filled up before they went to Collins's house, or after they arrived there. He said he believed his father had filled it up after they arrived, and that it had been executed in the kitchen. Then came the question about the floor. The court asked about the kitchen floor, and here Edward Barton Jr. gave an answer that became one of the more memorable moments of the trial. He said, "I cannot charge my memory with that. We both dined there that day, and I think we had some fowls and a piece of bacon for dinner." The significance of this lay in the contrast with Nicholas Luff's evidence. Luff had specifically mentioned the brick floor of the kitchen, a detail that anchored his account in a particular physical reality. Young Mr. Barton could not remember the floor, but he remembered the dinner, fowl and bacon, on a June day in 1729. This kind of detail, specific and incidental and unconnected to any legal question, has a particular quality in the memory, the quality of something genuinely experienced rather than constructed. A man who was fabricating his recollection of a day would be more likely to remember the document and the witnesses than the menu. He was asked whether he had seen Nicholas Luff at Collins's house. He said he did not remember seeing him. If he had been there, he would have appeared as a servant coming in and out, and he had not paid attention to servants. He said he did not know whether he had ever seen Nicholas Luff before or since. He was then asked to look at the word junior in his signature on the bond, and to confirm whether that too was his own handwriting. He said, "Yes, I do believe it is." The character evidence for the defence then began in earnest, and it was of a quantity and social weight that must have made a significant impression on the court. Hampshire had sent a delegation to the Old Bailey that represented by any measure a substantial portion of the county's respectable society, and they came to say, in varying degrees of emphasis, 2 things: that Edward Barton was an honest man who would not commit forgery, and that the principal witnesses against him were people whose word was not to be trusted. A Mr. Williamson came first, and he identified himself, when asked, as having served as High Sheriff of the county the previous year. He said he did not know much of the Collinses himself, but that by all report their general character was very bad. He said, "I have heard they are very litigious people, and frequently concerned in lawsuits. They bear so very bad a character that I would not believe them upon their oaths, and I believe a great many others would not. I think their characters are so very bad that they ought not to be believed." He noted that he lived in Exeter, and that the 2 John Collinses lived in Hambledon parish, 3 or 4 miles distant. He confirmed that Honor Luff lived in his own parish, and that she bore a very bad character there. He said he was upon his oath when he added that he should not care to believe her upon her oath. Mr. Bonham followed with a similar account. He had known John Collins and Honor Luff, and had formerly lived near them. He said, "They never wronged me, but their general character in the neighbourhood is an evil one. 'Tis generally bad. I should give no credit to him or her, though they were upon oath." He had known Mr. Barton for 30 years. His assessment was of the warmest kind. "Mr. Barton I have known 30 years. He is a gentleman of a good paternal estate, and married a woman of a good family. I don't believe he is capable of being guilty of forgery, nor is there a man in our country who believes him guilty. His character is a very good one." He was then asked, since he had done so much business in the neighbourhood, whether he had seen Collins within the last 7 years. He could not say whether he had or not, but he had seen Honor Luff some months ago at Alresford, and he had an estate within a mile of the place where they all lived, and all people gave them an evil character. John Barnard, Esquire, gave evidence next. He knew Collins of Hambledon the elder, and offered a detail that painted the Collins family in a particular light. About 10 years ago, he said, Collins's son had been indicted for setting the moors on fire. He had known Honor Luff for 20 years. He said their general characters were all bad, and that he really believed none of them were to be credited. Of Mr. Barton, he said, "Mr. Barton bears as good a character as any gentleman in the county. He's a man of good substance, and I believe would scorn to do what he's charged with, as much as any man in the kingdom." A Mr. Penton offered a careful assessment. He had known Mr. Barton for 15, 16, or 20 years, and said he had always behaved well in his profession. He characterized Barton's situation. "He is a man of fortune, not much less than £200 a year, but I don't know his circumstances particularly. His general character is exceeding good, and I believe he would by no means do a thing of this sort. He lived about 7 miles from Mr. Barton, and knew nothing of the Collinses." A Mr. Clark had a particular qualification to speak to Barton's career. He said, "In 1704, I got Mr. Barton sworn an attorney. He had done business for him since, and had never known him to do an unfair thing. He said, he always behaved as well as ever I knew a man in my life, and I took him to be a very honest man." Edward Wools said that while he lived about 9 miles from the Collins family, and knew their character by general report, he did not know the Collinses personally. He said from the character he had heard of John and Nicholas Collins and Honor Luff, he thought they ought not to be believed upon their oaths. William Collier said the Collinses and Honor Luff bore a very bad character, and that he believed they were not to be credited upon oath. He added a particular detail. "I never heard anybody speak well of them in my life. I live about 8 or 9 miles off, but their characters ring pretty much about the country, farther than 8 or 9 miles. He said he had heard this character of them before Mr. Barton had even been concerned for them, which suggested the reputation predated any specific grievance arising from this dispute. Edward Snuggs confirmed the same from his own locality. He lived within 4 miles of the 2 John Collinses. All 3 of them, the Collinses and Honor Luff, had very bad characters, and he did not think they ought to be believed upon oath. Edward Hooper, Esquire, added considerable weight to the defence. He was himself in the Commission of the Peace, a justice of the peace for the county, and his assessment of the Collinses was therefore not merely that of a neighbour, but of a man whose official duties regularly involved assessing the credibility of those who came before him. He said he had known Mr. Barton 20 years, and had never heard but that he bore an exceeding good character. He said, "His family is very well respected in the country. I always took him to be a man of substance, and beloved by all his neighbours." He then spoke of the Collinses from his official perspective. He said, "I am in the Commission of the Peace myself, and have often heard the gentlemen in the Commission complain of the Collinses being uneasy, troublesome fellows. They have the characters of bad men, and if they were to come to me for a warrant, I would not take their oaths." He was asked by the court whether, if the Collinses had such bad characters, a man of Mr. Barton's good character would have been employed by them. It was a fair question, and Mr. Hooper's answer had the virtue of brevity and honesty. Probably he might not know them. At the start of a professional relationship, an attorney did not always know the full history of his clients. He took them as they presented themselves. Mary Webb lived about 2 or 3 stones cast from Honor Luff. She had known her and the Collinses for 10 years. She said, "Their general character is so very bad that I think they are not to be believed upon their oaths." She had not kept company with them for a long time, though she rented a house from them. She said, "I never go near them, but when I carry my rent, and then I never stay longer than I have an acquittance." Charles Mitchell confirmed the same. The major part of the people in the country would not believe what the Collinses said, and he would not believe them on their oaths. Edward Aslett had known Mr. Barton for 30 years. He had done business for him and his father. He said, "He has a very good character, and I don't think he would be guilty of what is now laid to his charge." Thomas Hammond, who was Deputy Register under the Bishop of Winchester, gave evidence that was both character testimony and something more. He said the Collinses had been at law for 16 years, a remark that placed them firmly in the category of inveterate litigants. He spoke of Barton in the strongest terms. No man more religious and devout, nor better respected than he is. He added that Barton held an office under the bishop at that time. But then he gave an account of a conversation at the assizes that touched on the motivations behind this prosecution. He said he had spoken with Mr. Reed there, and had raised the matter of a gentleman of good character being charged with a serious offence by people of bad character. And Mr. Reed had said in response that Honor Luff was a mad girl, and that as for the 2 Collinses, nobody would believe them, and that Mr. Barton had not been cautious enough with them, and that he himself would never trust them with his handwriting. This account of what Reed had said out of court, if the jury believed it, was significant. Here was the very attorney who had helped the Collinses bring their complaint, who had advised them through the process, who had made possible the chain of events leading to this trial, allegedly describing the Collinses as people nobody would believe. The implications for the credibility of the prosecution's entire case were considerable. John Hannington then gave evidence of another conversation, one that seemed to illuminate Mr. Reed's attitude toward Mr. Barton and his family. He said he had been at a vestry meeting, present along with Mr. Reed and Mr. Barton, Jr., when the rating of the parish books was taking place. When the committee reached Mr. Barton's name in the rate book, Mr. Reed had raised the assessment. Young Mr. Barton had protested, saying he would not have his father's house rated so by every person, and Mr. Reed had told him he would humble him, and his father too. And then he had said, "Don't you remember the bond?" The implication was plain enough. Mr. Reed had, according to this witness, expressed an intention to use the bond as an instrument against the Bartons, had said as much directly to young Mr. Barton in a public meeting. Whether this was credible, whether the jury would accept this account, was another matter. But if they believed it, it suggested that the prosecution had its origins not in genuine outrage at a forgery, but in a neighbourhood quarrel and a personal animus. Thomas Newnham, Esquire, said he had not known Mr. Barton long personally, but had known his character ever since he had come to live in the county. He believed Barton was universally respected. From the character I have heard of him, I believe he is the last man in the world who would be guilty of forgery. Nicholas Pyle, Esquire, who had served in the Commission of the Peace for some years, said he had always esteemed Mr. Barton a man of fortune and character, and could not think him guilty of anything of this kind, but far from it. William Edwards then gave evidence on a specific and rather striking incident. He had happened to be in the same house as Honor Luff about 4 years ago, the previous February. A man present had said to her, "If you would do yourself any good, you must deny all and swear anything." And she had answered, she would deny all and swear anything before she would come to the parish. The phrase is worth dwelling on. To come to the parish was to fall upon the parish poor relief, to become a pauper dependent on the vestry's charity. It was one of the most feared descents that a person of modest means could face, combining material destitution with social humiliation. If Honoria Luff had said she would swear to anything to avoid that fate, and if the jury believed this account, then her entire testimony fell under the deepest suspicion. She was, on this reading, a woman who had said explicitly that she was prepared to perjure herself for material advantage. Mr. Porter, an attorney, said he had known Mr. Barton 18 years and believed the prosecution to be malicious, designed to extort money from him. He added that he was himself currently acting in a cause for Lady Boyce against the Collinses, which placed him as a partisan in a broader dispute involving the same family. Then came a moment that might have complicated the defence, and that the court recorded with apparent interest. Mr. Reed, who had already given evidence earlier, was called again, or spoke again in some capacity, and his account of the characters of the prosecution witnesses was rather different from the testimony of all the Hampshire gentlemen who had preceded him. He said, "I have known the two John Collinses and Honor Luff 15 or 16 years. And then, as to Honor Luff, I never heard anything amiss of her in my life. As to old John Collins, I have. But young Collins, I believe he is an honest man." He was asked directly whether he thought old John Collins would forswear himself. He replied, "I don't know." He said he believed Honor Luff would not, because she had been very cautious when making her affidavit to ground the suit in the Court of Common Pleas. He was then pressed on whether he had told Thomas Hammond that the Collinses were people of ill character. His answer was careful and somewhat defensive. He said he had said that old John Collins bore a bad character, and that he believed the young one was an honest man, and that he had no reason to distrust Honor Luff. He did not recollect having said she was a mad girl. He gave his account of the conversation with Mr. Hammond at the assizes. He said Mr. Hammond had wished they might not be troublesome to him, meaning to read, and he had replied that he had done nothing for them but what he had done for people he thought were right, but that if they had a mind to quarrel with him, he did not know that he had given them anything under his hand. Then he made a remark that acknowledged something of the complexity of his own relationship with the Collins family. He said, "The Collinses indeed have not been very grateful to me, for after I had done them all the service I could, they were pleased to tax all my bills." So Mr. Reed, too, had had his bills taxed by the Collinses. He, too, had found them difficult clients. And yet he had helped them bring this complaint against Mr. Barton. Whether his motivations were entirely straightforward, and what the remark about not knowing that he had given them anything under his hand was meant to convey, the record leaves tantalizingly unclear. The prosecution then called its own character witnesses in rebuttal, and several people came forward to speak well of the Collinses and of Honoria Luff, people from the same Hampshire country and from London. Richard Tribe gave evidence that stood in particularly sharp contrast to the Hampshire gentleman's testimony. He had known Honor Luff a good many years, and knew no harm of her. He said, "She bears a good character, as far as I have heard. She is a young woman, and may be guilty of frisky things, but I never knew her guilty of anything dishonourable." He spoke of John Collins, the younger, in equally positive terms. He said, "I believe he would no more take a false oath to take away a man's life than I would." And then he offered the critique that may have been the most intellectually pointed observation made by any witness in the entire trial. He said, of the many Hampshire gentlemen who had given evidence against the Collinses, most of them who gave evidence never had any dealings with them. Then how should they give a character of them truly? It was a fair point. Several of the gentlemen had described themselves as living 7 or 8 or 9 miles from the Collinses. Several had said they knew nothing of the family from their own experience, but only by general report. General report of this kind, travelling through the neighbourhood of a county town, was not always reliable. It could reflect genuine knowledge, or it could reflect the accumulated prejudices of a social group, the settled low opinion that the respectable held of those they considered troublesome, transmitted from one respectable person to another until it acquired the solidity of fact. Richard Tribe gave an account of himself that placed him as a man of some complexity. He has been born at Hambledon in Hampshire, bred up as a surgeon, but had lived various places over the years, sometimes in the country and sometimes in London, and now kept a public house near Hanover Square, selling wine, brandy and rum wholesale and retail, and had been a settled housekeeper for about 12 months. He had known the Collins family for 20 years, and he said that old John Collins had once been well respected, trusted by the squires and gentlemen of the county, his youthful days having given no indication of the reputation that now attached to his name. He had also never heard anything bad of Mr. Barton. Thomas Martin said he had known the two John Collinses for 30 years, having encountered them when he lived in Hampshire, and having seen them when he visited from London, most recently, about a month ago. He said they bore a good character, and he did not think they would forswear themselves. He was a housekeeper in Trinity Minories, a shoemaker by original trade, now cleaning gloves and carrying a light at funerals. Thomas Batsman had known the Collinses 4 years, and Honor Luff likewise, though he had never been to Hampshire himself. He lived in the Strand, in London. He said they all bore good characters as far as he knew, and that he was acquainted with various people who came from that part of the country. A Mr. Moody had been bred and born in Hampshire and still lived there. He had known the two Collinses many years, and Honor Luff for about a year or two, and had never heard any harm of any of them in his life. When asked whether he thought they would come to court and forswear themselves, he replied with admirable plainness, "I know nothing of that. I would not do it for all the world." A Mr. Cole, a house carpenter, said he had known Honor Luff for 12 years, and had not heard anyone give her a bad character, and it was his opinion that she would not forswear herself. John Goldsmith lived near Honor Luff, and had known her for 10 years. He said he knew no harm of her. When pressed on whether she would forswear herself, he gave an answer that acknowledged the limits of what he could honestly say. As to her forswearing herself, I have nothing to say in that respect. As to her character, I can say nothing as to her character. I know the two Collinses, and for my part I know no harm of them. They have bad characters, but I know no harm of them. The last witness had given the court, in a few words, the essential difficulty of character evidence as a means of determining truth. He had heard the Collinses bore bad characters, and yet from his own knowledge of them he knew no harm. Which should a jury believe? What a man had heard, or what he had experienced? And to what extent was general reputation, particularly in the close communities of the English countryside, a reliable guide to anything beyond the social standing of the person being discussed? The court now had everything before it: the testimony of the prosecution witnesses and the testimony of the defense witnesses, the physical document in evidence, the conflicting accounts of a day in 1729, and a weight of character evidence on both sides that the jury would have to assess and assign its proper value. The jury acquitted the prisoner. The words are brief in the record, as they always are at the Old Bailey, where the verdict is the conclusion and everything else has been the means of arriving at it. The elaborate proceedings of the day, the witnesses from Hampshire, the attorneys and the magistrates and the former High Sheriff and the Deputy Register of the Bishop of Winchester, the competing memories of a kitchen and a dinner and a piece of parchment, the question of who had been in the room and who had not, the examination of handwriting and the assessment of marks. All of this resolved, in the end, into a single word spoken by the foreman of the jury: acquitted. To understand what the acquittal meant and what it did not mean requires thinking carefully about how the jury would have approached its task. This was not an age in which juries were instructed to be satisfied beyond a reasonable doubt, a formulation that belongs to a later period. But the underlying idea that a conviction on a capital charge required a degree of certainty that excluded the serious possibility of innocence was well understood. Juries in capital cases were not supposed to convict a man to death on evidence that might be wrong. They were supposed to be sure, or as sure as human beings can be about the acts of other human beings, before they delivered the verdict that would send him to Tyburn. In this case, the evidence against Mr. Barton was all testimonial. There was no independent proof that the bond had been forged. There was no unambiguous expert comparison of handwriting that established beyond question what had happened. There was the testimony of witnesses who said that the bond was wrong, that the witnesses named were not the witnesses present, that the signature of George Collins did not look like his writing, that the name of young Mr. Barton on the witness line looked more like the elder Barton's hand than the younger's. And against all of this testimony stood the direct denial of Edward Barton the elder, the direct affirmation of Edward Barton the younger, and a very substantial body of character evidence from the most respectable quarters of Hampshire society. The character evidence was, in this period, not merely background colour. It was evidence given under oath that went directly to the question of whether the testimony on each side was to be believed. A jury that believed the Hampshire gentlemen when they said the Collinses and Honor Luff were not to be trusted upon their oaths had good reason to discount the prosecution's entire case. A jury that believed Richard Tribe's observation that most of the gentlemen had never actually dealt with the Collinses had reason to be more sceptical of the character evidence itself. The complexity was genuine, and the jury's task was genuinely difficult. But they acquitted, and the reasons we can infer from the evidence are persuasive enough, even from this distance. The charge was capital. The principal witnesses against Barton were people whose reputation for veracity was disputed by many who knew them, and corroborated by only a handful who, by the defence's account, knew them much less well. Barton himself and his son both gave direct, consistent, and, in the case of the younger man, memorably specific testimony. The fowl and the bacon. The dinner served on a June day in a Hampshire kitchen 11 years before. And then there is the peculiar note at the very end of the trial record. After the jury had given its verdict, it was moved that Mr. Barton should be given a copy of his indictment. This was a standard enough request for an acquitted defendant. The indictment was the formal legal document setting out the charges, and a copy of it, stamped with the court's record of acquittal, served as a form of protection against being tried again on the same charge. In a world before formal records of acquittal were routinely kept in searchable form, having the physical document was a practical protection. But the court, after hearing counsel on both sides, refused to grant it. This is not explained in the record. The courts of the 18th century did not typically give reasons for procedural decisions of this kind in their published reports. But the refusal is there, noted, significant in its oddity. An acquitted man, asking for the standard documentation of his acquittal, was refused. Something in the court's view of the case, some reservation or complication or procedural difficulty, that the surviving record does not reveal led to this outcome. It is the kind of detail that opens rather than closes. It suggests that the acquittal was not unambiguous vindication, that the court retained some doubt or some concern, that the verdict of not guilty was not the same as a finding that the bond was genuine and the prosecution had been purely malicious. What exactly the court thought, we cannot know. What exactly happened in that kitchen in Hampshire in 1729, with its brick floor that Nicholas Luff remembered, and young Mr. Barton could not, we cannot know. Edward Barton walked out of the Old Bailey a free man. He had his life. He had the testimony of every respectable man in his county that he was honest and incapable of forgery. He had his estate and his marriage and his practice. At least in so far as a public forgery trial in the most famous criminal court in England had not permanently altered the way his neighbours looked at him. The Collins family returned to Hampshire. Whatever lay behind their complaint, whatever they had genuinely believed or genuinely suffered or genuinely hoped to achieve by bringing this case, the verdict had given them nothing. The record of the Barton trial is the last glimpse the Old Bailey proceedings give us of them, and then they pass back into the Hampshire countryside and the ordinary texture of lives that the historical record does not otherwise illuminate. Honor Luff, young and described by one witness as prone to frisky things, returned to Hambledon. Nicholas Luff, who had been sent for as a witness in a kitchen and had come, returned. Mr. Reard, the attorney who had helped the Collinses bring their complaint, and who had then made some rather complicated statements about their characters, returned to his practice. Thomas Hammond, who had reported Reed's words about a mad girl and the inadvisability of trusting the Collinses with one's handwriting, returned to his duties under the Bishop of Winchester. And the bond for £83, that parchment document with its seals and its contested signatures and its disputed witnesses, was filed away in the records of the court, where it remained for anyone with the patience and the Latin to find it, until eventually the whole body of the Old Bailey proceedings was transcribed and made available in searchable form. And tonight's narrator found it. And here we are. The jury acquitted the prisoner. The words are brief in the record, as they always are at the Old Bailey, where the verdict is the conclusion and everything else has been the means of arriving at it. The elaborate proceedings of the day, the witnesses from Hampshire, the attorneys and the magistrates and the former High Sheriff and the Deputy Register of the Bishop of Winchester, the competing memories of a kitchen and a dinner and a piece of parchment, the question of who had been in the room and who had not, the examination of handwriting and the assessment of marks. All of this resolved, in the end, into a single word spoken by the foreman of the jury. Acquitted. To understand what the acquittal meant and what it did not mean requires thinking carefully about how the jury would have approached its task. This was not an age in which juries were instructed to be satisfied beyond a reasonable doubt, a formulation that belongs to a later period. But the underlying idea that a conviction on a capital charge required a degree of certainty that excluded the serious possibility of innocence was well understood. Juries in capital cases were not supposed to convict a man to death on evidence that might be wrong. They were supposed to be sure, or as sure as human beings can be about the acts of other human beings, before they delivered the verdict that would send him to Tyburn. In this case, the evidence against Mr. Barton was all testimonial. There was no independent proof that the bond had been forged. There was no unambiguous expert comparison of handwriting that established beyond question what had happened. There was the testimony of witnesses who said that the bond was wrong, that the witnesses named were not the witnesses present, that the signature of George Collins did not look like his writing, that the name of young Mr. Barton on the witness line looked more like the elder Barton's hand than the younger's. And against all of this testimony stood the direct denial of Edward Barton the elder, the direct affirmation of Edward Barton the younger, and a very substantial body of character evidence from the most respectable quarters of Hampshire society. The character evidence was, in this period, not merely background colour. It was evidence given under oath that went directly to the question of whether the testimony on each side was to be believed. A jury that believed the Hampshire gentlemen when they said the Collinses and Honor Luff were not to be trusted upon their oaths had good reason to discount the prosecution's entire case. A jury that believed Richard Tribe's observation that most of the gentlemen had never actually dealt with the Collinses had reason to be more sceptical of the character evidence itself. The complexity was genuine, and the jury's task was genuinely difficult. But they acquitted, and the reasons we can infer from the evidence are persuasive enough, even from this distance. The charge was capital. The principal witnesses against Barton were people whose reputation for veracity was disputed by many who knew them, and corroborated by only a handful who, by the defence's account, knew them much less well. Barton himself and his son both gave direct, consistent, and, in the case of the younger man, memorably specific testimony. The fowl and the bacon. The dinner served on a June day in a Hampshire kitchen 11 years before. And then there is the peculiar note at the very end of the trial record. After the jury had given its verdict, it was moved that Mr. Barton should be given a copy of his indictment. This was a standard enough request for an acquitted defendant. The indictment was the formal legal document setting out the charges, and a copy of it, stamped with the court's record of acquittal, served as a form of protection against being tried again on the same charge. In a world before formal records of acquittal were routinely kept in searchable form, having the physical document was a practical protection. But the court, after hearing counsel on both sides, refused to grant it. This is not explained in the record. The courts of the 18th century did not typically give reasons for procedural decisions of this kind in their published reports. But the refusal is there, noted, significant in its oddity. An acquitted man, asking for the standard documentation of his acquittal, was refused. Something in the court's view of the case, some reservation or complication or procedural difficulty that the surviving record does not reveal, led to this outcome. It is the kind of detail that opens rather than closes. It suggests that the acquittal was not unambiguous vindication, that the court retained some doubt or some concern, that the verdict of not guilty was not the same as a finding that the bond was genuine and the prosecution had been purely malicious. What exactly the court thought, we cannot know. What exactly happened in that kitchen in Hampshire in 1729, with its brick floor that Nicholas Luff remembered, and young Mr. Barton could not, we cannot know. Edward Barton walked out of the Old Bailey a free man. He had his life. He had the testimony of every respectable man in his county that he was honest and incapable of forgery. He had his estate and his marriage and his practice. At least in so far as a public forgery trial in the most famous criminal court in England had not permanently altered the way his neighbours looked at him. The Collins family returned to Hampshire. Whatever lay behind their complaint, whatever they had genuinely believed or genuinely suffered or genuinely hoped to achieve by bringing this case, the verdict had given them nothing. The record of the Barton trial is the last glimpse the Old Bailey proceedings give us of them, and then they pass back into the Hampshire countryside and the ordinary texture of lives that the historical record does not otherwise illuminate. Honor Luff, young and described by one witness as prone to frisky things, returned to Hambledon. Nicholas Luff, who had been sent for as a witness in a kitchen and had come, returned. Mr. Reard, the attorney who had helped the Collinses bring their complaint, and who had then made some rather complicated statements about their characters, returned to his practice. Thomas Hammond, who had reported Reed's words about a mad girl and the inadvisability of trusting the Collinses with one's handwriting, returned to his duties under the Bishop of Winchester. And the bond for £83, that parchment document with its seals and its contested signatures and its disputed witnesses, was filed away in the records of the court, where it remained for anyone with the patience and the Latin to find it, until eventually the whole body of the Old Bailey proceedings was transcribed and made available in searchable form. And tonight's narrator found it. And here we are. Let the night settle around you now. The court has risen. The jury has given its verdict. The clerks are gathering their papers and tying them with the red tape that gives the expression its name, binding up the record of the day's proceedings against the time when someone will need to consult it. The candles in the sessions house are being snuffed one by one, and the smell of extinguished tallow moves through the empty room, where, a few hours before, a man's freedom and his reputation hung in the balance. Outside, London continues its nighttime business. The watchmen make their rounds. The river moves. The moon, if it has held through the evening, is reflected in the Thames's broad surface, moving with the water. Fleet Street is quiet now, the coffee houses closed, the print shops dark, the legal offices locked. The only people on the street are those who have nowhere else to be, and they move quietly between the pools of lantern light. The churchyard of St. Dunstan's in the west is at peace. The gravestones stand in their familiar ranks, some of them marking people who had lived and worked in this neighbourhood of lawyers, who had carried papers and argued cases and sat in judgment and gone home in the evening to unremarkable lives that are now entirely forgotten, except for the stones that carry their names. The grass between them is damp with the April night. Somewhere beyond the city, the road to Hampshire stretches westward through the dark. It passes through Basingstoke and through Winchester, where the cathedral stands in its ancient close, and the bishop's officials manage the affairs of the diocese, including, until recently, The small matter of Edward Barton's office. Beyond Winchester, the road continues south toward Hambledon, through the chalk hills and the river valleys, past the farms where the spring planting is already underway, and the hedgerows are coming into leaf. By the time news of the Old Bailey verdict reaches Hambledon, it will be worn smooth by the telling, simplified by the distance it has had to travel. History holds its secrets lightly. It lets the documents speak, and when they stop speaking, it falls silent and offers no further explanation. We do not know what Edward Barton thought as he left the court and walked out of Old Bailey Lane and back into the life that the verdict had preserved for him. We do not know whether he felt relief or anger at the months of anxiety he had been put through, or something quieter and more complicated than either. We do not know whether the Collins family, on their way back to Hampshire, believed they had been cheated of justice, or whether they had privately known, in some part of themselves, that the case was weaker than they had presented it. We do not know who was right. What we know is what the record tells us. A bond for £83. A kitchen in Hampshire with a brick floor, remembered by one witness and forgotten by another. A dinner of fowl and bacon on a day in June 1729, remembered by a young clerk and apparently by nobody else. A mark made by a woman who said the mark before the court was not hers. A signature on a witness line that one attorney thought looked more like the father's hand than the son's. And at the end of it, a jury, 12 men of the required property qualification, who heard everything and said not guilty, and went home. And perhaps that is the most honest ending a story of this kind can have. Not a resolution, not a final settling of what had really happened, but a verdict, which is something different. Courts decide. Truth does not always follow the verdict. The law gives us an answer. It does not always give us the fact. And the people who lived these things took their private knowledge with them into the future that the historical record cannot follow, carrying what they knew about that kitchen and that parchment and that afternoon, until they no longer knew anything, and the knowledge went with them. You are warm. You are safe. Whatever this day held for you, it is now receding. The hours between now and morning belong to you, and they make no demands. The things that needed to be done today have either been done or will wait patiently for tomorrow. The world will continue without your attention for a few hours, which is something the world has always been quite capable of doing, whatever any of us may think. You are allowed to rest. You are allowed to let the day go. The story is complete. The bond has been disputed, and the bond has been argued over, and the jury has spoken, and the court has risen, and the record has been set down in the archive, where 300 years later it was found and unfolded and read out, very slowly, in the dark. That is all it needed to do, and it has done it. Let your breathing find its own pace now. Let your thoughts, if they are still running, find somewhere comfortable to stop. There is nothing you need to hold. The night is wide and quiet, and it holds you as easily as it holds everything else in it. The river and the old stones and the long road to Hampshire, and all the ordinary sleeping lives of people who have no idea they share the night, with the memory of an £83 bond and its 12 good men who could not be certain, and said so. Let that be enough for tonight. Sleep well.